At this stage, as the CL is getting granted or has been granted, a few scenarios might get developed with regards to the licenses, which needs to be addressed by the controller. Section 88 talks about the power of controller to deal with such scenarios. Let's go over them. Starting with discussing one such scenario as defined by section 88.1. There could be a scenario where a patentee might have put unreasonable conditions in a license or upon purchase of a patented article, which are negatively impacting the use, sale, manufacturing of articles which are not even protected by the patent. In such cases, the controller, upon request made by the applicant, can grant a license under the patent to the applicant as well as to the customers of the applicant. Moving on to another scenario. Remember, a person applying for CL could be a person who is already a holder of a license. In such case, either the previous license could be cancelled or the previous license could be amended to include favorable terms and conditions. Next up is another scenario where an applicant has obtained a CL under a patent. But the applicant is of the opinion that this patent cannot be worked without infringing one or more patents of the patentee. In such case, CL can be provided to one or more such patents also, related patents also. Let's move to another interesting case where a CL was granted to an applicant, and after working the invention for a period of time, the applicant realizes that it doesn't make any business sense to him. The terms and conditions are proving to be unfavorable for him to continue. What can he do? Interestingly, the applicant can reach to the controller with a request to revise the terms and conditions. But he can only approach the controller after he has worked the invention for a minimum of 12 months. So what is the process? So as per section 88.4, rule 100, the applicant needs to use form 20 to reach the controller for revising the terms and conditions. The same approach is followed where the controller goes over the application to see if a prima facie case is made or not. A hearing opportunity is given to the applicant to explain himself before deciding whether such an application will be allowed or not. Interesting trivia about this request is such a request can only be made once, not again and again. So let's assume the controller allows such a request. Then what happens? A notice is served to the patentee. And thereafter you know the drill. Document submissions, evidences, and hearing. Post-hearing, the controller passes a judgment allowing or disallowing the terms and conditions request made by the applicant. In case it is allowed, the terms and conditions are revised. So with this, we have discussed all provisions relevant to the compulsory licensing. Here is the summary of what we discussed, starting from the application, going towards the termination of the CL. The forms are also mentioned for your easy reference. I hope you found this video informative and it would have cleared a few of your doubts. I'll see you in the next episode as we discussed another interesting topic around patents. Till then, be good and take care.